I'm here to testify in favor of all the pending legislation addressing the gun safety issues. Now, what I wanted to say today was I wanted to take a step back and
Is your button up, Professor? Up is good, down is...
yes. Can you hear me now? Yes. What I want to do was, as I said, I'm here to testify in favor of all the pending legislation before the House regarding gun safety. And what I want to do was I want to focus on sort of step back at the larger picture legal issues surrounding these measures. Now, I suspect that opponents of the pending legislation will take the view that the legislation is somehow outside of the legal authority of the House or violates constitutional rights. I'm here to tell the committee that view is wrong. Okay? There is nothing in the pending legislation that is outside your authority, and the pending legislation does not violate any constitutional rights. Now, in order to explain that, let me just let me approach this from the view of the opponents of the pending legislation. Now, the legal foundation for the opponent's view is going to be, of course, based in the Second Amendment and the most important Supreme Court case that's ever been decided on the Second Amendment, which is called the District of Columbia versus Heller. Those are the two bases that form the legal foundation for the opponents of the legislation. The opponents embrace the Heller decision. So what I want to do is I just want to read a couple of paragraphs, a couple of sentences from the Heller opinion. This is straight from Heller, okay? Like most rights, the right secured by the Second Amendment is not unlimited. From Blackstone through the 19th century cases, commentators and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. This is straight from Heller, okay? It goes on to say, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. This is a law of the land as stated by the Supreme Court. This is the opinion embraced by the opponents of the pending legislation. So I just want to remind the committee and the legislature that everything that's been proposed is consistent with Heller. And that's all I want to do this evening. Thank you very much.
Thank you, Professor. Representative Philippi.
Thank you, Professor. This is kind of an academic issue, so I appreciate you being here. When the court finds that someone is in extreme danger, they must find by clear and convincing evidence that, and that's the standard to remove their Second Amendment rights. And then at that point, the burden seems to flip, where now the disarmed individual has to prove at a future court date by clear and convincing evidence that they are no longer in extreme danger. What other constitutional rights are subject to the petitioner having to prove beyond a clear and convincing evidence that they're enabled to get them back?
Well, the first thing I would want to point out about that is that the initial standard is clear and convincing. Clear and convincing is one of the highest standards imposed by law. In order for a judge to decide that something has been established, has satisfied the clear and convincing standard, that is such a high showing that it provides almost as much protection as a law can provide to anyone who is accused of something. So I think starting from that basis, it is a high bar, and it is high protection for anyone accused.
I'm glad you said that, because the burden then shifts, does it not, to the citizen at a later date to use that same very high standard to prove their fitness to possess firearms. And so I revert back to my question. What other constitutional rights are taken away, and then it's up to the petitioner in order to get them back to cross such a high burden?
Well, I have read the legislation, and I don't remember exactly what the language is, but I will operate on your representation, and I accept that that's what it's going to be. But it seems that if the clear and convincing standard has been met in one instance, it doesn't make sense to me that it can then be removed by a lower standard. And so it seems to me that that would pass constitutional muster, because it puts the parties on equal footing. As I said, I don't see that it would make sense to say, okay, you, the accused, the court has found that you have engaged or you have satisfied this situation by a clear and convincing standard, and then later, that same accused person who's been found liable for something under clear and convincing can somehow come back and reverse that finding on the basis of a much lower standard. To me, that imbalance just doesn't strike me as being the correct approach.
I mean, it would seem the appropriate standard at a later hearing would be a continuing finding by the court of clear and convincing evidence that the person was still a danger, instead of essentially a prohibition on that person's rights until they are able to return to the court. I'm just concerned that, many times people have mental illness, and we know that mental illness can be cured and people get better. I'm concerned about the presumption that that person is still mentally unfit, and requiring that person to have that high burden, as you said. Just for the committee, I think maybe a better standard would be, in a subsequent hearing, the court would have to find again by clear and convincing evidence that the person was unfit, as opposed to putting that burden on the citizen to vindicate their constitutional rights.
Actually, that makes sense to me.
Me too.
Glad we got
Thank
that
you,
cleared
Professor.
up. You should come to committee more often, Professor. We can have a lot of fun with it. Representative Knight.
As an aside on that back and forth, and I think I agree with you, Rep. Philippi, on your proposal about a continuing danger. It makes me feel better a little bit, but I do think it's constitutional the way the bill's written now, and I refer, by way of example, to civil commitment. I remember from law school, I was interning with Massachusetts Department of Corrections and had the opportunity to watch a civil commitment trial where somebody was trying to get out. Now, they had been civilly committed, obviously against their will, and their liberty was taken away, a constitutional right. And then when it came time that that person wanted to get out, he had to prove to a jury that he was safe enough to be out on the street. So he basically had to prove himself to get his constitutional rights back. So using that as an example, I think as it's written, it's okay. But if we did it your way, that's the way we normally do the process around all our protection order frameworks.